welcome to our program. I'm Rachel Pierce, and I'm joined by my colleague Alan Dorhofer today. Today is the first in a new series of interactive broadcasts that are going to deal with advanced guideline issues. Today, specifically, we're going to be dealing with advanced guideline issues in relation to firearms offenses. We're going to be looking at various fact patterns that we have received either from the helpline, from training programs that we've done in the past, or from faxes that we've received prior to the broadcast and during this broadcast as well. We're going to look at those fact patterns and analyze them and address some of the issues that we see that come up frequently in dealing with firearms offenses. Now, going through our program today, we're going to start out with a review of relevant conduct. We're going to move on after that to a discussion of 2K 2.1, the general firearms guideline, where you find your felon in possession offense cases sentenced. Then we're going to move on to a discussion of 18 U.S.C. 924C, which is the use, carry, or possession of a firearm in relation to a crime of violence or a drug trafficking offense. And we're going to finish up today's broadcast with a review of multiple counts and grouping. Now, the majority of our broadcast today is going to focus on those two guidelines that I mentioned, 2K 2.1 and 2K 2.4, because that's the guidelines, those are the guidelines that are used when you're looking at a majority of firearms offenses. But we're also going to touch on the subjects of relevant conduct and grouping of multiple counts because we've found that the majority of issues that come up in relation to firearm offenses center around the analysis of relevant conduct and the grouping of multiple counts of firearms offenses. But before we get into the meat of the program, so to say, Alan, would you mind going over some of the housekeeping issues that we need to be aware of for today's broadcast?
Sure. We have participant materials which are listed at the bottom of your screen at the following website, starting with the HTTP. And what we would like is throughout the show we are going to be seeing a fax number that comes on the screen. And we would greatly appreciate any faxes that you have regarding any of these issues. The issues that we get over the helpline and also over the training requests are going to be used in some of the scenarios that Rachel and I are going to talk about today. But we would like for you to send any questions you have on firearms or any guideline issues to the following number that you will be seeing along the screen today.
Thank you, Alan. Now let's go ahead and get started with a review of relevant conduct. Any of you who have seen us train in the past might have heard us use the phrase that relevant conduct is the cornerstone of guideline application. And the reason why we call it the cornerstone of guideline application is because really and truly relevant conduct is the foundation on which all of, or a majority of, your guideline determinations are to be made. Your Chapter 2 base offense levels, specific offense characteristics, the application of cross-references, and the majority of Chapter 3 adjustments are going to focus and center on the application of relevant conduct. So it's very important when you have these issues that come up when you're applying the guidelines that you have a clear understanding of how relevant conduct works and the analysis that you're going to need to work through. So having said that, Alan, why don't you walk us through the analysis that we need to be concerned about when we're looking at relevant conduct?
Sure. As many of you know out there, relevant conduct, the guideline that you're going to be looking at is 1B1.3, A1, A2, A3, and A4. We're going to focus most of our attention today on 1B1.3, A1, and A2 analysis because those are the subsections that you use most frequently, especially with the firearms guidelines. As with all relevant conduct questions, there are two questions that you would like to know about. One, who and when. Who are we going to hold accountable for certain acts, and when are we going to hold those people accountable for it? The first question deals with 1B1.3, A1A. We're going to hold the defendant accountable for all of the acts that that defendant has committed in that offense. 1B1.3, A1B, we're going to look to certain acts of others in certain circumstances, particularly conspiracies. And there's a three-part analysis that we're going to focus on when we look at 1B1.3, A1B, to look at the scope of the defendant's undertaking with his co-conspirators. We're also going to look to whether those acts of others were in furtherance of those of the defendant's undertaken. And then third, we're going to be looking to see whether those acts were reasonably foreseeable in furtherance of that activity. The second question, as I mentioned, is the when question. And what we're going to be looking at with when is we're going to look to the offense of conviction and certain other parts of that offense of conviction. We're going to hold the defendant accountable for under 1B1.3A1 anything that occurred during the offense of conviction, anything that occurred in preparation of that offense of conviction, and anything that occurred to avoid detection of that offense of conviction. And let me give a brief example of something about how 1B1.3A1 operates. If a defendant decides that he's going to rob a bank, and before he robs that bank, he decides that he needs a car and steals a getaway car, we're going to hold the defendant accountable for anything in preparation for that offense of conviction, the bank robbery, and hold that defendant accountable for the fact that he stole that getaway car. We're also going to hold the defendant accountable for anything that occurred during that offense of conviction. If the defendant took out a firearm and pointed it at the teller and walked out with $50,000, we're going to hold that defendant accountable for that fact. And then we will also look to anything that the defendant did to avoid detection of that offense. So if, as he's running out of the bank, he hits a teller on the way out on the steps of the bank, we're going to hold the defendant accountable for those actions to avoid detection of the offense. And those are going to be the primary questions that you're going to look for when you're looking at 1B1.3, the who and the when. Then there's a second prong for certain type of offenses dealing with 1B1.3A2 that will look to the same course of conduct, common scheme, or plan. Rachel, do you want to give a little description about how 1B1.3A2 operates?
Sure. As Alan was talking about, the relevant conduct analysis is different depending on what types of offenses you're looking at. And by that we mean that for certain types of offenses, the court will be able to look beyond that offense of conviction. Remember, the offense of conviction timeframes are during the offense, in preparation for that offense, or in order to avoid detection or responsibility. But when you have A2 of relevant conduct, the court can look beyond or expand that offense of conviction to look at things that are part of the same course of conduct, common scheme, or plan. Now, one of the things to remember, and we'll talk a little bit more about this when we talk about grouping, because grouping of multiple counts at Rule D and expanded relevant conduct are very much intertwined. But when we're specifically looking at firearms offenses, we can look at 3D1.2D and see that 2K2.1, which is one of the primary firearms guidelines, is listed as groupable under Rule D. Now, what does that mean? Obviously, it means we're going to group it at Rule D, but it also means that it's subject to expanded relevant conduct, okay? Now, expanded relevant conduct is not a term that you're going to see in the guideline manual itself. It's actually another one of the training terms, similar to cornerstone of guideline application, that we've kind of coined in the training unit to describe what actually happens when the court looks beyond the offense of conviction to include certain acts in the determination of relevant conduct. If you look a little bit more closely at the guideline, Application Note 9 of 1B1.3 will guide the court in how to determine what offenses are same course of conduct, common scheme, or plan. The court will be looking at things such as, do the offenses have similar modus operandi? Do they have close proximity between time and offenses? Are they regular offenses? This type of thing. Those are the determinations that the court's going to be making to determine whether or not something is part of the same course of conduct, common scheme, or plan. Now, the reason why this is so important with these types of offenses, and specifically firearms offenses, is that you may be able to look at, in this case, other weapons that are outside that offense of conviction and include those in your relevant conduct determination. So why don't we just discuss a scenario to see how this would play itself out?
I think that's a great idea, and I think, as with all guideline applications, scenarios are a good way to illustrate certain points that we all try to make when we're looking to the guideline applications. So why don't we look at a scenario in which a defendant has been charged with a 18 U.S.C. 922G, felon in possession, and the indictment cites one firearm for that offense. However, a subsequent search of the defendant's house yielded an additional 14 weapons that were found at that house. One of the questions is, does the enhancement for number of weapons at 2K2.1B1 apply? During the course of this broadcast, we're going to talk about a number of the specific offense characteristics at the 2K2.1 guideline. One of them involves the number of weapons. And there's an enhancement for if the offense involved 3 or more weapons. Here, you have a situation where the indictment cites one firearm. However, there were an additional 14 firearms that were found at the individual's house. In the course of the fact that the individual was a felon in possession and should not have been possessing any of those weapons, not only are we going to hold the defendant accountable for that one weapon, we're also going to hold the defendant accountable for those additional 14 weapons, which would be a grand total of 15 weapons. At that enhancement at 2K2.1B1, the number would be 15 weapons, which would equate to a 4-level increase for having 15 weapons, which is between the 8 and the 24 enhancement at that guideline. So that's how the relevant conduct works, is that you don't just count the weapon at the indictment. There may be beyond what Rachel mentioned earlier, that same course of conduct, common scheme, or plan.
Okay, Alan, you mentioned one of the specific offense characteristics at 2K2.1, but let's back up just a little bit and look at the guideline itself at 2K2.1. 2K2.1 is the guideline that deals with unlawful receipt, possession, or transportation of firearms or prohibited transactions involving firearms. And I've mentioned already that this is the felon in possession guideline and one that is used very often. Let's just talk a minute about that guideline. Those of you who are familiar with that guideline know that there are alternative base offense levels at 2K2.1. Depending on the defendant's criminal history, the status of the defendant, is the defendant a prohibited person? And then there are a number of specific offense characteristics. Alan touched on already a table at 2K2.1 that deals with number of firearms. So there's incremental increases based on the number of firearms involved in the offense. I'd also like to point out here that in November of 2006, the Commission made a number of amendments to the guideline at 2K2.1. And for those of you who are interested in reading the reader-friendly version of those amendments and finding out a little bit more about them, we do have a link to those reader-friendly amendments provided for you at the site which you registered for your participant materials. So you can download the reader-friendly version of those amendments. Now, what you'll see when you look at that is a couple of things. A new specific offense characteristic, for example, for trafficking of firearms was added as a result of that amendment. A circuit split was resolved regarding B6 and C1, and we'll go into a lot more detail about that in just a few moments. You'll also see changes in determining base offense levels for the certain types of offenses that are listed at 18 U.S.C. section 921A30. Those of you who are familiar with these offenses will recall that that was a repealed statute dealing with the ban on assault weapons. So we've provided an alternative way to determine what base offense levels would be for those types of offenses that were originally listed at that statute. Having talked about that, let's go ahead and dive into some of the application issues that we really want to focus on today. And I mentioned the 2K2.1 B6 and 2K2.1 C1, which is the cross-reference discussion. Let's start by looking at 2K2.1 B6. The language itself at 2K2.1 B6 says if the defendant used or possessed any firearm or ammunition in connection with another felony offense, or possessed or transferred any firearm or ammunition with knowledge, intent, or reason to believe that it would be used or possessed in connection with another felony offense, increased by 4 levels. Now, as I said, Alan, the Commission resolved a circuit split regarding specifically the application of B6 and C1. Why don't you tell us a little bit about how the Commission resolved that circuit split?
Yes, the Commission looked in examining the firearms guideline last year, and there were 3 circuit conflicts involved with the 2K2.1 B6 guideline. It's Amendment 691, if you want to look at Appendix C, to explain why the Commission did certain things with this guideline, particularly the circuit conflict. The first circuit conflict it had to address was the actual standard to be used in looking to 2K2.1 B6. Many of you that are watching will realize that 2K2.1 B6 used to be 2K2.1 B5, but it has been renumbered based on the fact that we have added that trafficking specific offense characteristic that Rachel just briefly mentioned. There was a split in the circuits on what is the standard for possessing or using the firearm in connection with another offense in that application. The majority of circuits used a standard that was the firearm must serve some purpose or facilitate the felonious conduct rather than being merely coincidental. 2 other circuits, though, used a little bit more of a broader standard, which was that the enhancement applies if the firearm reflected an increased danger of violence unless it was clearly improbable that the weapon was connected with the offense. The Commission examined this. It looked closely at a Supreme Court case called Smith versus the United States back in 1993, and in Application Note 14 of the guideline, the Commission went in and put in a new standard. And that standard is if the firearm facilitated or had the potential of facilitating another felony offense or another offense, then the enhancement would apply. Let me just give a brief little example of how this operates. If a defendant committed a bank robbery but was only convicted of that felon in possession, this guideline at 2K2.1b6 in this characteristic will look to whether the defendant committed another offense with that felon in possession charge. If the defendant used that weapon in the bank robbery, then we're going to apply that enhancement at 2K2.1b6. The Second Circuit conflict that the Commission resolved involved a burglary situation. What to do in the situation where a defendant burglarizes a home or sporting goods store and while in the midst of the burglary steals a firearm. Some circuits had held that during that burglary, if the defendant steals that firearm and walks out of the house and there's no other activity, that enhancement still could apply because of the increased danger of that individual having that weapon during that burglary, while some other circuits had said that the burglary would not rise up to that other offense at 2K2.1b6. The Commission resolved this with a bright-line rule to state that in the case of a defendant who takes a firearm during the course of a burglary, even if the defendant did not engage in any other conduct with that firearm during the course of the burglary, then at that particular point, the enhancement would apply. And the Commission had another circuit conflict it had to address, which was with the drug trafficking situation. The Commission resolved the circuit conflict to state another bright-line rule that when a firearm is found within close proximity to drugs, drug manufacturing materials, or drug paraphernalia, that the enhancement at 2K2.1b6 automatically applies. An example of this would be if a defendant is arrested in his house with a firearm next to the drugs that he's selling out of his house, that enhancement at 2K2.1b6 applies. And the reason that the Commission did this was because of the increased danger with both the burglary and the drug context with firearms.
Okay, thank you, Alan. Let's move on now and talk a little bit more about the cross-reference, and then we'll talk in a few more minutes about the similarities, because people are going to notice when we go over the language at 2K2.1c1 that there are a lot of similarities in the language. Having said that, let's just go ahead and look at the language at the guideline. If the defendant used or possessed any firearm or ammunition in connection with the commission or attempted commission of another offense, or possessed or transferred a firearm or ammunition with knowledge or intent that it would be used or possessed in connection with another offense, then the cross-reference would apply. Now, I would like to point out here that the cross-reference only applies if the offense level that results is greater, okay? Another point I want to make is that even since the Booker decision came down, the standard of sentencing, the standard of evidence at sentencing is preponderance. So while we're looking at applying specific offense characteristics and cross-references, we still have the same standard of evidence in a post-Booker world, which is preponderance of the evidence. So cross-references are still alive and well, and especially in relation to this guideline, because we see a lot of instances in which a defendant is charged with a felon in possession or and an underlying offense. So we're going to be seeing a lot of these things happen. A couple of other things I want to point out when we talk about applying the cross-reference at 2K2.1c1. 1B1.5, which is the interpretation of references to other offense guidelines, says that if there are two offenses to which a cross-reference could apply, then what you need to do, according to Application Note 3, is apply the cross-reference based only on the most serious of those offenses. Now again, relevant conduct is very important in determining what cross-references are at 2K2.1. And if you've got a couple of different offenses that the defendant has committed, let's say, for example, the defendant is in possession of a weapon, robs a bank, shoots a teller throughout the course of the event, and actually kills that teller, you've got a federal offense for felon in possession of a firearm. Now, regardless of whether or not the defendant's convicted of the robbery or the murder of the teller, sometimes they will be, sometimes they won't. There are two offenses that defendant attempted or committed another offense with that weapon. So you're going to look to the most serious of those two offenses, which is the murder, obviously, of the teller, and cross-reference on the basis of that offense as opposed to the robbery of the bank. Okay. We've looked at the language differences, or we've looked at the language of 2K2.1b6 itself and the language at the cross-reference. Let's talk about some of those differences and some of those similarities, if we will, right now, Alan.
Right. And one point I do want to make that was Rachel just made to emphasize, both for the specific offense characteristic and the cross-reference, no conviction is necessary. because that's an important point to keep in mind, is that the defendant does not need to be even charged in some situations with that other offense. The court will have to make a determination if that other offense rises up to the level of another felony offense at B6 or the cross-reference that we're going to look at C1. So no charge is necessary for that enhancement.
Exactly.
Some of the differences between the cross-reference and the specific offense characteristic, the first difference is the specific offense characteristic at 2K2.1b6 looks to whether the weapon was used or possessed, the firearm, in connection with another felony offense. The cross-reference, though, looks used or possessed any firearm in connection with the commission or attempted commission of another offense. So we're looking at the commission or attempted commission and also of another offense, meaning it could be a misdemeanor. Doesn't have to be, but it could be a felony or a misdemeanor for the cross-reference. So in that situation, it's a little bit more broad because of the misdemeanor language. 2K2.1b6 and 2K2.1c1, another difference is at the specific offense characteristic, it needs to be the weapon needs to be possessed or transferred with the knowledge, intent, or reason to believe that it would be used or possessed in connection with another offense. Whereas the cross-reference, it's the possession or transfer of the firearm with knowledge or intent that it would be used or possessed in connection with another offense. So we're looking at both, again, the reason to believe language at 2K2.1b6. That language is not at 2K2.1c1. So those are two of the differences. In general, though, there really aren't that many practical differences between the two. As a matter of fact, even if you use a misdemeanor to cross-reference to look to see whether it applies, you're not normally going to cross-reference because the misdemeanor offense is unlikely to result in a greater offense level than what was at the 2K2.1 offense level calculation that you had done in connection with that offense at 2K2.1. Why don't we look at a scenario, Rachel, to illustrate this point? We'll look at a scenario where the defendant is charged with 18 U.S.C. 922G.
The facts of this scenario indicate that the defendant robbed a fast food restaurant with the firearm, and of course that firearm is listed in the charging instrument, the violation of the 18 U.S.C. 922G. Now, the defendant has been charged and convicted for robbery at the state level and actually sentenced to 11 years on that robbery. And so the question comes up as to whether or not 2K2.1b6 in connection with another felony offense and or the cross-reference at 2K2.1c1 apply. So let's look at the application on these two counts, or on this count of conviction. The 2K2.1, the felon in possession guideline, results in a base offense level of 18. We are going to apply the enhancement at 2K2.1b6 as the defendant did use the firearm in connection with the robbery, used the firearm to rob the fast food restaurant. That's a 4-level increase. Now, before the cross-reference, we have an offense level of 22. Now, if we were to apply the cross-reference on the basis of that other offense, in this case a felony offense, we would apply the robbery guideline. The robbery guideline, of course, is at 2B3.1, provides a base offense level of 20. We're going to give the specific offense characteristic at B2 for the defendant possessing a firearm in connection with that offense. It's a 5-level increase. So in this case, we see that we would be cross-referencing out. And I think the point that we really need to make here is that anytime you're looking at the application of 2K2.1b6, you should also necessarily be looking at the application or possible application of the cross-reference at C1. And even though there are some differences in the language, and if it's a misdemeanor offense that you're looking at, you know, the cross-reference is going to unlikely apply because it won't result in a greater offense level, you still need to be looking at the application of both at the same time. We've got another scenario that we can look at to illustrate some of the issues that come up. Alan, you want to take the lead on this?
And the reason we're spending a lot of time on this specific offense characteristic, this is a characteristic that actually applies in about 20% of all cases that are sentenced under the 2K2.1 guideline. And we get a lot of helpline calls and a lot of training when we're doing their training programs, a lot of questions on this. So we can do another scenario now to illustrate the example of both the specific offense characteristic and the cross-reference. In this scenario, which is from an actual helpline call, defendant was armed at the time that he walked into a bar, and he entered the bar with his girlfriend. He got into a fight with the waiter and hit the waiter with a bottle. While the defendant was driving away, the defendant was pulled over by the police officer who noticed the firearm in the front seat of the vehicle. At that particular point, the defendant was arrested and charged and convicted of 18 U.S.C. 922G, felon in possession. In looking to the actual guideline, the question is, does 2K2.1b6 and or the cross-reference at 2K2.1c1 apply? Once again, in looking at the analysis for this particular guideline application, 2K2.1 is going to be your guideline that you're going to look at. Base offense level we'll put for this defendant at a base offense level of 18. 2K2.1b6, because the individual possessed that firearm in connection with that assault, by that individual hitting that waiter, is another 4-level increase. The offense level is 22. But once again, you need to continue on that guideline to look to the cross-reference to see if the cross-reference applies. Here, the other offense that took place was the assault. 2A2.2 is the guideline for aggravated assault. That base offense level is 14. There is a 3-level enhancement if during the course of the assault a firearm was possessed or a dangerous weapon. Here we know the firearm was possessed. We're going to give a +3 for 3 levels. And then at 2A2.2b3, bodily injury resulted by the fact that the defendant hit the beer bottle with the hit the waiter with the beer bottle. Another 3 levels, offense level 20. You do not apply the cross-reference at that particular point because it's less, so you'll stay at the 2K2.1 guideline. When you are calculating the guidelines, you'll stay at 2K2.1.
Mm-hmm. Good. I'm glad we looked at examples of both. One where we actually do cross-reference because it results in a higher offense level, and one where we don't. Even though the other offense in this case could have been a felony offense, it still didn't result in a higher offense level. And again, just to reiterate the point of anytime you're looking at the application of 2K2.1b6, you must also look at the application of the cross-reference. I can't tell you how many times we've gone out training and people have said, oh, we apply B6 and we don't even go any farther than that. Well, that's not applying the entire guideline. And so you always have to remember to do that. So anything else you want to add before we?
Yeah, and one other point to make with these characteristics. There are a lot of these characteristics apply in a lot of these firearms cases. Some people have said you need to pay close attention to the fact that the number of weapons and the trafficking specific offense characteristic can both be applying. The same thing with stolen weapons. There's an enhancement for stolen weapons, and there is also a number of weapons. So if the individual stole 50 weapons, he's going to get hit with an enhancement for the fact that he stole the 50 weapons, and he's also going to get hit with the 2-level increase for possessing a stolen weapon. So you need to pay close attention when you're looking to these specific offense characteristics that you could have more than one applying based on the facts of the particular case.
Okay, great. Okay, so far we've discussed relevant conduct, the review of relevant conduct. We've discussed the firearms guideline at 2K2.1 and some of the issues that occur there. Before we move on, however, to discussion of the 924C violations, I want to address one more issue. It was actually a fax that we received prior to the broadcast from the Southern District of Georgia. Thank you to Suzanne Mingeldorf and Stephen Highsmith, and I'm sorry if I butchered those names. But thank you for submitting this question. And the issue is this. The defendant has been charged with a violation of 18 U.S.C. 922G and is also a prohibited person. When applying 2K2.1, there is a reduction for if the offense was solely for lawful sporting purposes. If the weapon was possessed solely for lawful sporting purposes, there's a reduction that could apply. And the question is, if the defendant is a convicted felon, in what circumstances would this reduction ever apply? Alan, do you have any thoughts on that?
Yes, and this reduction, which is pretty significant for some defendant because it takes them down to level 6 for some of these individuals, what the court looks to is the guideline itself at application note 6 talks about the circumstances for the court to look, certain circumstances for the court to focus on. The number and type of firearms that are involved in the offense, the amount and type of ammunition, the location and circumstances of the possession or actual use. Look to the defendant's criminal history. See if he has other felony convictions dealing with firearms in his past. And the extent that the possession is restricted by local law. And in this is a specific offense characteristic. There's some case law out there that I think would be helpful to individuals to look at this. There's a case out of the 8th Circuit in a case called the United States versus Massey, and there's a case out of the 10th Circuit in a case called U.S. versus Moet, which I think would be very helpful to individuals in looking to this application at 2K2.1b2, because it is something that for defendants it can take them down to that level 6. So it is a pretty significant decrease for those individuals down to a particular type of offenses.
Okay, good. Again, thank you for that fax prior to the broadcast. If you have questions as you're watching now, go ahead and fax those to us, and we'll try to get to them at the end of the broadcast. If we don't, we will call you back after the show or at some point during this week, hopefully, and answer those questions. Now let's go ahead and move on to a discussion of 18 U.S.C. 924C offenses. Now, of course, I mentioned earlier in the broadcast, 18 U.S.C. 924C deals, and the guideline at 2K2.4, deals with the use, carry, or possession of a firearm in relation to a crime of violence or a drug trafficking offense. Those of you who are aware of 924Cs and have dealt with them in the past, know that the 924C statute is a unique statute. As a result, the guideline at 2K2.4 is a unique guideline, and it does not operate in the same fashion as an overwhelming majority of Chapter 2 guidelines. And we'll talk about that, but let's talk a little bit about the statutory construction first, because that's really what drives the application of the guideline itself. So, Alan, why don't you tell us a little bit about the statutory construction of a 924C?
Yes, this is a unique statute because it's got different mandatory minimums. It's got one statutory maximum. The statutory maximum is life, but mandatory minimums depend on certain type of conduct, type of weapons that the defendant possessed, and also potentially some prior 924Cs. One of the first questions the court's going to look to is, what is the mandatory minimum that is appropriate for this individual? 924C, 18 U.S.C. 924C has varying lengths of mandatory minimums, but none are less than 5 years. So at a minimum, the defendant will be facing 5 years imprisonment. The judge will make a determination if the defendant possessed, used, carried, brandished, or discharged. And the mandatory minimums term depends on what the defendant did in that offense. And the reason the judge makes that decision is from a case called U.S. v. Harris from the Supreme Court. As a matter of fact, we're going to see a couple other Supreme Court cases. This statute, 18 U.S.C. 924C, has been the subject of a number of cases before the Supreme Court. Also, with this, the brandish carries the 7 years, use carries the 10-year mandatory minimum. For prior 924C convictions, those will increase the mandatory minimum length that the court will also be given at that particular point. And then we'll also be looking at the type of firearm. Certain types of firearms lead to increased mandatory minimums. And that's something, though, that will be in the indictment of that individual. So, for example, a machine gun carries a 30-year mandatory minimum, different than if it was just a regular pistol. The other area that is unique about this statute deals with if an individual has a second or subsequent conviction. And this second or subsequent conviction of a 924C can occur at the same sentencing. So a defendant could be charged with 2 counts of 924C. Or he could have had one in his past and one now, but that second or subsequent conviction will lead to an increased mandatory minimum. And the Supreme Court said that it was acceptable for the second or subsequent one to occur at the same sentencing in the case Deal versus United States, the site on your screen, as you could see. For the second or subsequent conviction, mandatory minimum is typically 25 years. The other point, and this is a very important point that we're going to emphasize, if the defendant is convicted of 924C, that sentence must be consecutive to any and all other sentences. And that's specifically cited in the statute and also in the U.S. versus Gonzalez case. And one other important point to remember is, even though it's carrying a weapon or using a weapon in connection with a certain type of offense, you could actually just have a conviction for this statute alone. You do not need a conviction for that other offense. And that's an important point to be aware of, that then obviously the mandatory minimum will control.
And as a result of this particular statutory construction, as I said before, the guideline operates a little bit differently at 2K2.4 because of this. And it's actually kind of straightforward what we tell you to do at 2K2.4. We say apply the mandatory minimum for the 924C count or counts. And again, that's going to depend on the behavior that the defendant was involved in. Did he possess the weapon? Did he brandish the weapon? You know, what did he do? Do not apply for 924C counts any Chapter 3 adjustments or Chapter 4 to the 924C count. Of course, as there are exceptions to every rule, there is an exception if the 924C count could make the defendant a career offender. But that is going to be a subject for another day. We're not going to discuss that 924C career offender today. A couple of things I do want to point out when you do have 924C convictions is that the application of specific offense characteristics can be impacted as well. For example, if you've got a 924C violation and a offense of conviction for the underlying offense could be a drug trafficking offense or a crime of violence, you're not going to apply any firearms specific offense characteristics for that underlying offense. And of course, those of you who are familiar with the drug guideline know that there's an increase at 2D1.1b2 for possession of a weapon. If you have a drug count in connection with the 924C, you're not going to be giving that weapon enhancement because the 924C is going to count for that underlying conduct, okay? In addition, if there's a co-defendant who's carried a weapon as part of a drug conspiracy, but the defendant has not, okay, or has not, the defendant has not carried a weapon, you're not going to be giving any SOC increases for weapons based on co-defendant's behavior.
Right.
Okay, you might have had a 924C that was originally charged and then dismissed or something like that. But if you have the 924C, you're not giving that at all. Right. In addition, did you want to?
Yeah, just one point with that. It is one point to make is, and a defendant can be convicted, though, of 924C based on that co-defendant actually carrying that weapon. So that's one thing to keep in mind is that the co-defendant can lead to the conviction at 924C, but it is a little bit of a different analysis when you get to the actual guidelines themselves. Right.
In addition, a lot of times in these types of cases, we see also a conviction for felon in possession of a firearm. So you're going to be applying the guideline at 2K2.1. Again, you don't give the specific offense characteristic at B6, which is in connection with another felony offense, because again, the 924C is going to account for that behavior, whether it's the defendant's behavior he's responsible for through the application of relevant conduct. It doesn't, however, affect any of the other specific offense characteristics or the base offense level or the cross-reference.
Right.
Just wanted to make that point. Let's take a look at another scenario. In this scenario, we have a defendant who's charged with selling cocaine in violation of 21 U.S.C. 841 B1B, also carrying a firearm in connection with that offense in violation of 18 U.S.C. 924C, and an additional charge of felon in possession of a firearm in violation of 922G. Subsequent search of the defendant's house yielded an additional 3 weapons that he had carried. There was evidence that he had carried in past drug sales. The question here being, does 2K2.1 B6 apply? Alan, what would you say?
Yes, in dealing with this situation is because, once again, you're looking to the defendant's relevant conduct, we are not going to apply that characteristic based on that 924C conviction. So with this situation, you are not going to be applying those characteristics, and that's why it's very important to pay close attention to the facts of that particular case, because you may have a situation where a defendant is charged with 3 bank robberies, and at those situations where the 924C only counts for one of the bank robberies, you might actually at that particular point be counting for certain other bank robberies some of the characteristics as well. But bank robbery is different than a felon in possession because of the grouping rules.
Okay, so let me make sure I understand you. Even though these offenses that were found at the at the defendant's house, the weapons found at the defendant's house could be considered as part of expanded relevant conduct based on earlier conversations that we had, we're not going to give the enhancement at B6 because of the 924C conviction.
Correct.
Right?
And that's why it's very important when you're looking to 924C to look to the relevant conduct of that offense, because that will really determine whether these characteristics apply. Okay. And the other thing I think that's important to make also, I know when Rachel and I go around the country talk about firearms, is there are other enhancements, though, that could potentially occur because of the 924C conviction that you still may give if an injury results from a firearm being shot or something along those lines. You would still give that enhancement. We're talking about weapon enhancements are being precluded by 924C.
Okay.
So.
Okay. Well, I think that kind of covers the gamut on what we wanted to talk about with 2K2.1 and 2K2.4. So I guess now we're going to move on to a discussion of grouping.
Right.
Let's start off our discussion of grouping with looking at the grouping rules themselves. And of course, you'll find these grouping rules at 3D1.2. And they're listed as A, B, C, or D. Rule A deals with counts that involve the same victim or the same act. For example, if a defendant has kidnapped and assaulted a victim, that could be grouped under Rule A. Rule B deals with same victim, 2 or more acts. A lot of times you'll see a conspiracy count, substantive counts that relate to that conspiracy grouped under Rule B. Rule C deals with conduct treated by characteristic. If you have a specific offense characteristic or other Chapter 3 adjustment that incorporates the conduct of that other count, that's going to be a Rule C grouping. And then last, but certainly not least, as it is used in a majority of the cases, is grouping under Rule D, which is grouping offenses based on an aggregate. We talked a little bit earlier about how we have a list of offenses at Rule D that are groupable under Rule D. And you see when you look at these offenses that they're firearms offenses, drugs, fraud offenses, types of offenses where you're adding money or drugs or guns, adding things up and applying the guideline based on some sort of aggregate behavior. Now, when we look at grouping offenses at Rule D, we know that 2K2.1 is listed at Rule D. So multiple counts of 2K2.1, multiple counts of felon in possession are going to group pursuant to Rule D. Well, now, how does that work? How it works is that you only have a single application for 2K2.1, and you base it on all of relevant conduct. So if we take a look at an example, we have 4 counts here of felon in possession of a firearm. And conceivably, each of these 4 counts, the indictment is going to list a different weapon. But what we do when we apply the guideline at 2K2.1 is we apply one application based on all of the weapons that are noted in that count of conviction. And of course, this may impact whether or not one of the weapons was used in connection with another offense, the number of weapons in the offense. One of the weapons could be a destructive device and trigger the application of that specific offense characteristic. So when you're looking at applying the guideline, you do one guideline application, 2K2.1, based on all of relevant conduct. However, Rule D is not the only rule that is impacted when we're looking at firearms offenses. Other grouping rules can be implicated. Alan, would you like to show us an example of a case where it's not going to be a Rule D grouping?
Sure. And Rule D grouping obviously applies in a lot of these situations, but there are going to be other times where other rules may come into play. And let's give a couple scenarios of what we mean by that. In the first scenario, we're going to have a defendant who's convicted of 2 counts, one dealing with drug trafficking, 21 U.S.C. 841, another dealing with 922G, 18 U.S.C. 922G. Count 1, the drug count, will do an offense level of 28 for the amount of drugs, plus 2 for the fact that the defendant had a weapon involved in that offense level 30. Count 2, which is 2K2.1, offense level 24, we're going to give a 4-level increase because the defendant possessed that weapon in connection with another felony offense, which is the drug charge at 21 U.S.C. 841, gives him an offense level of 28. However, as we emphasized earlier in the broadcast, you have to look to see if that cross-reference applies. When you look to 2K2.1C1, we're going to apply the cross-reference because he possessed that weapon in connection with another offense. We're going to cross-reference over to the 2D1.1 guideline, and now you're essentially going to have 2 counts. The guidelines are going to treat this as 2 counts of drug trafficking. Your offense level is going to be 30, and now we're going to group under 3D1.2A, the rule that talks about the same victim, same act. So even though drugs and firearms can't be aggregated together, that is a situation where they can be grouped under 3D1.2A because of the application of the cross-reference.
Right, and it's because when you apply that cross-reference, what you end up having is the same act, which is the distribution of the drugs, which would result in the Rule A grouping.
Right.
What happens, however, if you don't apply the cross-reference? Does that affect the grouping decision?
Yes, because as we know, there are going to be times when the cross-reference doesn't apply. So let's look at basically a similar situation. Facts are a little bit different this time, in which there are 2 counts of conviction again. The defendant is charged with 21 U.S.C. 841. His offense level, though, this time comes out to a 20, based on an 18 for the offense level, plus 2 for the use of the weapon, or the weapon being involved in the offense. 2K2.1, though, this time, the offense level comes out higher, 24 for the offense level, plus 4 for the actual using the weapon in connection with another felony offense, 28. You would still look to see if the cross-reference applies. However, because the offense level is higher at 2K2.1 than it is at 2D1.1, that particular point means you will not cross-reference over to the 2D1.1 guideline, so you're going to stay at 2K2.1. So you cannot group under 3D1.2A. But, as Rachel mentioned earlier, there are other rules, 3D1.2C, which look to see whether the conduct has been embodied into another specific offense characteristic, or Chapter 3 enhancement, which in this particular case, because of that, at the 2D1.1 guideline, that weapon caused a 2-level increase. At 2D1.1B1 based on that felon in possession weapon that was there. We're going to group the two under 3D1.2C because that conduct at the drug guideline 2D1.1 involving that weapon has been embodied also at the 2K2.1 guideline. So we would be cross-referencing. We would not be cross-referencing, but you could still group those two counts of conviction together under 3D1.2C.
Another example of the importance of applying the cross-reference because it impacts all sorts of things, including grouping decisions.
Yes.
Now let's look at what if we throw 924C in the mix. We have count 1 here is a drug count. Guideline is 2D1.1. The base offense level is 18, of course, driven by the quantity of drugs. Normally, we would give, because the defendant possessed a weapon, we would give the 2-level increase, but we can't here because we have a 924C conviction. Moving on, so we have an offense level then of 18. Moving on to look at count 2, which is the felon in possession, the guideline is 2K2.1. Base offense level is 20. Again, normally we would give an increase at B6 for using a weapon in connection with another felony offense, in this case the drugs, but we can't do that because of the 924C conviction. We still have to move on to determine if the cross-reference would apply. And in this case, it does not apply because the offense level at 2K2.1 is a 20. Because we can't give that 4-level increase and the offense level of the drug count is 18, we're not applying the cross-reference. We would then group these counts, as you mentioned earlier, under 3D1.2C, and then tack the 924C on at the end. So there's, in this case, 5 years that runs consecutive to those other 2 counts that have been grouped under Rule C.
And I think that's a great way to look at 924C and try to wrap up what we've been talking about with 924C because of that consecutive language at the statute. There are a couple things that you need to do. It's very important because 924C looks not only at 2K2.4, but you're also going to be looking to 3D1.1B and to 5G1.2A at the particular guidelines. 924C count, remember, you must exclude from grouping with any other count. Also, very important, the sentence for the 924C count must be imposed independently and consecutive to those other counts for at the guideline applications. And then also, other counts where the firearm-specific offense characteristic not applied may still, though, group under 3D1.2C. And it's going to be important when you look to the application and the grouping rules to apply 3D1.2C.
That's right. We've covered a lot of information today. The application of 2K2.1, the application of 2K2.4, some of the issues that arise in dealing with B6 versus the cross-reference. And now we've got some time for faxes, and we actually do have a fax that we received from Karen Collins and Terry Lassiter for the Northern District of Texas. Thank you for this question. What we have here is we have a defendant convicted of a drug offense, so 1 count of the drug behavior, but that count is capped at 5 years. And then we have an additional count for a 924C violation. Okay. And the question is, in this particular case, the guideline range, and let's say it's 360 to life, is obviously going to be a lot larger than what the drug count is capped at, which is that 5-year statutory maximum. Is there any way the court can impose more than 5 years on this defendant, or and in addition to the 5 years that the 924C would carry, tacked on to the 5 years for the drug offense? Alan, you have any thoughts on that?
I do, and that's a great question, Karen and Terry. We've gotten that question before, and the guidelines actually, the Commission made a change to the 2K2.4 guideline to actually address this situation. Under 2K2.4, the sentence is to be the mandatory minimum for 924C. If the court's going to go above what the mandatory minimum dictates, so for example, if the court finds that the defendant brandished a weapon, which would be a 7-year sentence under the actual statute and under the guidelines, the court can go above that potential guideline, that sentence of 7 years from the mandatory minimum, but it must do it as an upward departure. And at the 2K2.4 guideline, at application note 2, there is a specific language to address that exact situation that Terry and Karen both had asked in the question. That is a very good question to ask, and it is one that does occur because there are going to be times where a court wants to go above what that mandatory minimum looks like. So, excellent question.
Okay. We actually do have another fax here. The question is, 2K2.1, application note 8, knowledge or reason to believe alludes that subsection B4 applies regardless if there is knowledge or reason to believe that the firearm was stolen or had an altered or obliterated serial number. Does this insinuate that 2K2.1 A4BI or any other 2K2.1 guideline where knowledge may be an issue, does that require similar logic as it relates to knowledge and reason?
Not necessarily, and I think there's a couple points involved in this question to try to address. Number one, and since it was mentioned 2K2.1, before looking specifically to the obliterated or serial number, there is no mens rea requirement. What I mean by that is it is strict liability standard. If the defendant is found in possession of that weapon that has been stolen, he's going to get a 2-level increase. He doesn't have to have knowledge or reason to believe that that weapon was stolen. And the same thing with the obliterated or serial number, and we specifically address that in the guidelines. In dealing with the knowledge requirement elsewhere in the guidelines, you can't just generalize the knowledge requirements to the other particular specific offense characteristics. So just because we have said that at 2K2.1 before looking to the strict liability standard, that looking to that specific offense characteristic, that the strict liability standard has come into play, that means that at 2K2.1 B6 or the cross-reference that there's no knowledge. There is still that knowledge requirement, or at 2K2.1 B6 at least, you're going to be looking to the reason to believe. And I think it's also very important to pay close attention to each application note of that guideline, because some of them address specific offense characteristics.
Mm-hmm.
So.
Thank you. And that question actually came in from Braulio Gloria from the Southern District of Texas. And again, if I didn't say your name right, I apologize. I think that's all we've got time for today. We don't have any more, unless there's another point you want to make.
Well, I think there's, just to wrap up on some of these specific offense characteristic points that Rachel and I have been talking about. When you go through this guideline application at 2K2.1, when you look to the offense levels themselves, the base offense levels, you're going to be looking for a number of different things, such as prior convictions. The Commission has made a number of amendments to this guideline. Rachel mentioned earlier Amendment 599, Amendment 691 that we talked about earlier. That's the one that looks to these specific offense characteristic changes that we made this year, such as 2K2.1 B6, and also looking to some of the trafficking specific offense characteristics. When you look to the trafficking specific offense characteristic, we're going to look primarily to what the defendant, and that's going to be very similar to a question that was just asked dealing with the knowledge requirement. We're going to look to the knowledge of the defendant at that guideline as well. So when you look closely to the trafficking specific offense characteristic, there might be a different knowledge requirement because you need to look to who that defendant is transferring this to. So that question, I just want to go back and sum up some points because it's a very good question to illustrate how the interaction between a number of the characteristics may apply based on similar conduct, but the standards are different for each particular specific offense characteristic, and such as trafficking and things like that. So I just wanted to add to that potential point.
Okay, great. Well, that's going to take care of it for us here today. If you have any further questions, feel free to call us on our helpline, and that number is 202-502-4545. Our next segment of advanced guideline application issues is going to air in June. If you have any topics that you would like to recommend that we address, go ahead and note that on your evaluation form. And unless you have anything else to add.
No, I just want to reiterate, we thank the people who faxed in the questions.
Yes.
Keep the questions coming in on our helpline number that was on the screen earlier. And with that,
thank you and have a great day.
Thank you.